Good afternoon, everybody in Radio Land. This is Glenn Winningham, House of Fern, and the program is Do You Know Who You Are? You're listening to These Changing Times radio station, and we're talking about sovereignty. I was, just as a little overview, I was visited by the FBI and the Texas State Police about a year ago last March, and at that time they told me that I'm listed as sovereign in their system. Previous to that, I noticed how the cops, they would see me doing things like speeding and things like that, and they never stopped me, or hardly ever stopped me. I suspected that something that might be the case, but it was quite interesting when they talked to me, and we talked for about a half an hour, and they told me that actually about 3 times. And I was starting to think, well, okay, you told me that twice before. So anyways, the purpose of this radio program is kind of like a workshop, and it's because anybody can do this, okay? Anybody. And it is especially applicable in any common law country on the planet, but actually based on what jurists are saying, judges and things like Blackstone, who was a well-known English jurist who lived in the mid-1700s. It's according to him, it exists everywhere on the planet, and what we're going to be talking about today, actually, this topic of discussion is attorneys. I have about 10 or 12 PowerPoint presentations that I go through when I do a private information share. That's basically the contents of the private information share that we go through. And this one is on attorneys. I started on it yesterday. So we'll do attorneys and probably start on something else as well today, maybe finish something else. I have a website. It's www.sovereigntyinternational.info. That's all one word, sovereigntyinternational.info. I've also got some groups. These programs, as I get them once I get the files from this program, I will convert it to a video, and then I will upload it to YouTube. And so I've uploaded to over 100 videos to YouTube. What I do is I put a link to the YouTube video on the group. I've got 3 groups, actually. I've got one group at These Changing Times radio website. And so that group on These Changing Times radio website is called sovereigntyinternational.info as well. You can go to These Changing Times radio website, and on the front page there's a link for groups. And if you click on that, you will see a bunch of groups. There's several groups that are on the website, and one of them will be sovereigntyinternational.info. I've uploaded some interesting documents there. My own photo ID affidavit that I use. One of the things that I do, the whole purpose of what I do with the police is I send them a registered letter that's to the chief judge and the chief prosecutor and the chief of police in every city and town that I travel in. I also send a registered letter to the county sheriff and the county attorney and the chief judge in the county. And I also send a registered letter to the Attorney General of the state and the director of the Highway Patrol. It started out, about maybe 10, 12 pages, and now it's about 20 pages. It's got court citations in it and things like that. And we cover all of that as part of another presentation that we'll go through probably maybe next week sometime, called Asserting Your Sovereignty, and it's how I assert my sovereignty and put them in the position. What it is you put them in the position of honoring their oath of office. They are stopped from proceeding. It's called estoppel. you put them in the position that they cannot proceed. You tell them how they are perjuring their oath of office, and you describe it in detail, and they can't do it anymore because now they know they can't claim plausible deniability. I am the king. Again, that's another presentation that we actually talked about yesterday, citizenship, and we're all kings and queens. But what happens is we get ourselves involved in, because of our ignorance of the law, we get ourselves involved in what the courts view to be contracts. And so the end result of that is that we lose our sovereignty until we assert it, okay? Again, because we are the king and the queen, all we have to do is say the word. You know, say the words, understand who we are, and say the words. And once you do, you just watch them scatter, okay? It's like turning the lights on and seeing the roaches scatter, because that's exactly what happens. And that's why, with myself, they put me down as sovereign in their system, because they're essentially telling all their subordinates, leave this guy alone, because he'll have you in jail if you mess with him. And that's true. Again, we really do have good government. Most of our public servants are just honest, hardworking people, but there are criminals mixed in amongst them, and we have to root them out and prosecute them. And I can't tell you how many times I've done this stuff. A good example is the Pennsylvania Attorney General. I sent one of my notices to the Pennsylvania Attorney General, and he sent me back, actually one of his assistants sent me back a letter in my notice. I tell him I don't have a driver's license, and I'm going to be traveling in your state, and you have no more authority over me than a Walmart rent-a-cop. And so anyways, and a bunch of other things, obviously. These ones were, about 10 or 12 pages, so they weren't that big compared to the ones now. But I have court citations in them and all sorts of stuff. Anyways, his assistant attorney general sent me back a letter saying that if you travel in Pennsylvania, we're going to arrest your butt and we're going to take you down and put you in jail. And that was great evidence. And he sent me back my letter with all of his stamps on it, showing that they had received it and everything like that. And then their letter saying they're going to put me in jail. And so I made up an affidavit of criminal complaint for treason, for sedition, for perjury of oath, all sorts of multiple felonies, and I sent it to the U.S. attorney, and I attached my evidence to my affidavit of criminal complaint, which was the evidence that they provided me, and I sent it to the U.S. attorney. About 2 weeks later, I got a letter from the U.S. attorney saying that they had referred it to the FBI. And then a couple of months later, I was looking on the website for the Pennsylvania Attorney General, and they had an acting Attorney General there. And so, that guy could be in jail for all I know. Very well could be. I don't know. Again, the point is that we really do have good public servants. If we bring up the right issues, if we lay the proper foundation, and they will take care of it for us. And I can't tell you how many times I've done that, and things like that have happened. So, again, you have to understand what's happening and how it's happening, and this presentation on attorneys is part of that understanding. But all of it kind of fits together. Again, once you understand what's happening and how it's happening, it's easily defeated. And again, you just put them in the position of honoring their oath of office. They all have an oath of office, and all of a sudden they don't want to talk to you anymore. And literally, what will happen is they'll see you and they'll turn and run the other direction. They don't want nothing to do with you, and I kind of like it. Anyways, right now we're talking about attorneys. Oh, I've got a couple other groups. They're called Administrating Your Public Service. Those are separate words. And so that's Administrating Your Public Servants at Yahoo and at Google. Those are private groups, and you can go there and request to join. I've uploaded documents that I've done, and I keep all of my latest material. I upload to the group so that people have access to the latest stuff that I'm doing. and plus people on there might have ideas on things and more questions. And so we discuss all of this stuff and how it works and the procedures on how things can be dealt with. So I have those two groups. I also have a YouTube profile. It's called Sovereign Living. So you can go to YouTube and just search for Sovereign Living, my profile, and you can find all of my videos that I've uploaded. Anyways, so that's about it. I'm also available to do private information shares for anyone that's interested. But other than that, this is the presentation on attorneys, and so we're going to go through that today, and probably get another one done as well. Anyway, so to start off, former Chief Justice of the U.S. Supreme Court, Earl Warren, said, quote, "Between 75 and 90% of all lawyers are either incompetent, dishonest, or both," unquote. And so, first of all, before we get too carried away here, to summarize this all up, attorneys are all foreign agents of the Crown, okay? And when I say the Crown, I'm talking about a corporation that's domiciled in the City of London that has nothing to do with England, that is owned and operated by the Vatican. And we're going to go through and talk about that today. So even in England, okay, they don't have a shred of authority because the Crown does not have a shred of authority in England, okay? If it's Elizabeth's crown, okay, as in the Queen of England, if it's her crown, it will have ER superimposed over the crown, which says Elizabeth Regina. That's her crown, okay? If it's just the crown, then it's not her crown. It is this foreign corporation that's owned and operated by the Vatican, and they're just criminals. They're thieves. Don't get me going. And these are their agents are attorneys, and we're going to talk about that more. And so, former Chief Justice of the U.S. Supreme Court, Earl Warren, said, quote, "Between 75 and 90% of all lawyers are either incompetent, dishonest, or both." And who would know but the Chief Justice of the Supreme Court, who himself is a lawyer. So let's keep moving. And found in Book 7 of Corpus Juris Secundum, Section 4, which is a section on attorneys, it says, quote, "He is, however, in a sense, an officer of the state with an obligation to the court," unquote. And so an attorney is an officer of the court, and his obligation is to the court. And well, he's an officer of the state with an obligation to the court. Okay, he has to do what the court tells him. And then it says further, it says, quote, "His first duty is to the courts and to the public, not to the client. And whenever his duties to his client conflict with those as an officer of the court in the administration of justice, the former must yield to the latter," unquote. And that's, again, taken from 7 Corpus Secundum, Section 4, under attorneys. So the point is that his duty is to the courts. He's not, you hire an attorney, he's not working for you, okay? Don't even get it in your head that he's working for you, because he is not working for you. He's working for the court. And if the court is interested in making some money, well, then that's what's going to happen. And that's what happens all the time, especially here in America. America has a bigger percentage of their population in prisons than any other country on the planet. And why do you think that is? That is because these attorneys and these judges are making royalties. They're issuing these bonds and putting these people in prison, and the prisoners are creating the money, and the International Monetary Fund is actually paying for all of this. And these judges and lawyers are making huge amounts of money. Most judges retire millionaires because of the fact of these Admiralty Maritime Court cases. And we talk about Admiralty Maritime Law in another presentation. But so this is all because of attorneys. Anyways, quote, "Clients are also called wards of the court." Okay, that's in Corpus Juris Secundum again, section Book 7, Section 4. So if you hire an attorney, then you're saying that I'm an imbecile. I can't make decisions for myself. I want this attorney to make them for me. You're saying you're incompetent. I mean, that's exactly what you're saying, okay? A ward of the court is an imbecile. A ward of the court is not competent to make up decisions of their own. A ward of the court is property. They can do literally anything they want. A ward of the court is their property, and it's all just a big commercial transaction. That's why they're representing you, because you're not competent to make decisions for yourself. The attorney's going to make decisions for you, and there is no such thing as an incompetent sovereign. Do you know who you are? So you can't hire an attorney, okay? I wouldn't say never hire an attorney, but certainly in a criminal matter. I mean, you got to be very careful. You got to make sure that you know the law enough that you're telling that attorney what to do, and fire his ass. If he's a court-appointed attorney, then he's certainly not representing you. Quote, the practice of law cannot be licensed by any state, and that's Schwer versus Board of Examiners, 353 U.S. 238. So you can have someone in there to as counsel, but if you have an attorney, you just sold yourself down the river. But you can have someone in there as counsel, and they cannot stop that. And here's another court case. The practice of law is an occupation of common right, unquote. And that's Sims versus Ahearns. That's found at 71 Southwest Reports, page 720, 1925. Again, and that goes back to common law in England, okay? If it's an occupation of common right, then that goes back to England. So that applies in any common law country. You have to understand that you don't need an attorney. They want you to think you need an attorney, but that's so the attorney can sell you down the river, and the judge and the attorney can make out like bandits. That's what that's all about. Quote, a retainer is a sum of money paid by a client to secure an attorney's availability to work for a client. The fee paid is considered earned at the time of payment because the attorney is entitled to the money regardless of whether he actually performs any services for the client, and the funds shall not be placed into the attorney's trust account, unquote. And that's Baranowski versus State Bar. That's at 154 California Reporter, page 752. And that's Washington State Bar News, committee reports, formal opinion number 173. So the point is, that's actually, that court case is 1979, too. I forgot to mention that. But the point is that when you hire an attorney and you pay him a sum of money, well, that money's gone, okay? And he doesn't have to do anything for you. Okay, there is no contract. You paid in the money and you just flushed it down the toilet, and the attorney can just walk away from the whole thing, and that money's gone. And the attorney, you know, that's why I say these people are just the lowest form of life there is, and the sooner they're exterminated off the face of this planet, in my opinion, the better. And we're going to learn some more about them too. In support. Okay, this is taken from Black's Law Dictionary, 5th edition, page 709. Inns of court. These are certain private unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar, unquote. Okay, now you got to know what Inns of Court is, okay, and what London is. London, first of all, the city of London is not part of England. Okay, when I'm talking about the City of London, I'm talking about the downtown part of London that has got a wall around it, and it's called the City of London. And there's a wall. There's, I think, about 10 or 12 gates that go through this wall into the city, and that's called the City of London. And that was never conquered by William the Conqueror in 1066. Okay. The Magna Carta, read the Magna Carta. They talk about them charging customs to go into this into the City of London. The City of London was never conquered by William the Conqueror in 1066. And anybody that's watched the convening of the Imperial Parliament, you know, watch that sometimes, because anyways, we'll talk about that in a minute. Let's keep moving with this Inns of Court. Okay, there's an American Inns of Court Foundation, and every state has local chapter of Inns of Court chapters. And I can tell you that the Chief Justice of the Arizona Supreme Court was on the American Inns of Court chapter in Arizona, and it said it right on her resume that they put it on the internet. If you want to go do a search on the internet for the American Inns of Court, and you'll find it on the internet. Anyways, back to the City of London. The Imperial Parliament buildings are located in the City of London. The City of London was never conquered by William the Conqueror. It's got several gates. One of the gates is called Temple Bar. And the only true law schools, okay, in the world are located in the City of London. Inns of Court is called one of them. And what those law schools teach is 800 years of jury trial decisions in Old England. And those decisions can be found in the Coke's reports and the English reports. They're in a law library that's going to have those kinds of books in it. And it's 800 years of jury trial decisions in Old England. Inns of Court is one of those law schools, and that's the only place they teach real law in the world. Everywhere else they teach jurisprudence, which is procedure, and they don't teach law. The City of London is foreign territory to the rest of England. The City of London is not part of England. It is foreign territory. During the convening of the Imperial Parliament, the Queen gives a throne speech from at the Imperial Parliament. The Queen goes to Temple Bar, and she has to ask permission to enter into the foreign territory. What happens is the Queen, if anybody's ever watched that, they will know that there's the Temple Bar is a big oak door. And the Queen will go there with her scepter and her entourage, and she will beat on that door, and the Lord Mayor of London will be on the other side, and he's the dictator in the City of London for the Vatican. And so what happens is that there's a little 1 square foot hole in the door. It's a small door and a big door. And he opens up that 1 square foot hole and looks through and says, "What do you want?" to the Queen of England, okay? And she has to get his permission to enter into that foreign territory. And then once she does, she has to walk 2 steps behind the Lord Mayor of London, and she has to have her head bowed because she is not a sovereign in that territory. This is foreign territory. It's owned and operated by the Vatican, and she's not sovereign in there. And she walks 2 steps behind the Lord Mayor of London with her head bowed during the whole time she's in there. You watch that sometimes. You ever get a chance to watch the convening of the Imperial Parliament, you'll see that stuff going on. So it goes back. This goes back at least to concessions of the Pope. Do a search on the internet for concessions of England to the Pope, 1213. Okay, and that's where King John swore allegiance to the Vatican. Well, why do you think he did that? He certainly didn't do it if he didn't have to, and he agreed to pay them tribute. And the reason is because the Vatican, the crown, is a papal corporation. It's owned and operated by the Vatican, and he had to swear allegiance to him. And it says here, quote, in the concessions of England to the Pope, 1213, it says, quote, "We will and establish a perpetual obligation and concession. We will establish that from the proper and the special revenues of our aforesaid kingdoms for all the services and customs which we ought to render for them, saying in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks, 700 marks, namely for the Kingdom of England, and 300 marks for the Kingdom of Ireland." Okay, so they arranged to make 2 payments, one at Easter and one in the fall, and 700 marks was for England and 300 marks is for Ireland. Well, Ireland's not even part of England anymore, or at least most of Ireland, and so anyways, and that's concessions of England to the Pope. So what happened, that was 2 years before the Magna Carta. And so then in 1215, 2 years later, the Welsh barons, his tyrant, King John, was busy trying to collect this money for the Vatican. And so obviously they didn't collect it because the Welsh barons rose up in rebellion, and they stuck a sword to his throat, and they said, "Here, King, we want you to sign this." And they made him sign the Magna Carta. And if you read the Magna Carta, you'll find all sorts of stuff in there about martial law being imposed on the people of England. And that's how the Vatican operates. Everything is under martial law. And it all goes back to the Vatican, and you can learn about that when we talk about martial law and commerce and those presentations that we talk about, where we talk about that kind of stuff. So, anyways, the bottom line is that So when and we'll also learn about what happens when any corporation goes bankrupt. Okay, because obviously they weren't able to make the payments. So what happened is they went bankrupt, and they were forced. The Vatican seized the corporation because when any corporation goes bankrupt, the creditors become the owners, and so the Vatican became the owner, and now it's owned and operated by the Vatican, and has been for hundreds of years. And so after the concessions of England to the Pope was signed, King John had to make money to pay his tribute. King John imposed martial law rule and started do things to raise money to pay his tribute, and it took only 2 years for the people to figure out what was happening, and the Magna Carta was the result. And here's a court case that talks about it. This is a Canadian court case, a Quebec court case. You know, I can't tell you how many people come up to me and tell me that there's no common law in Quebec. Well, BS, okay? There is common law in Quebec, and this is a perfect court case for it, because this court case is called Perlman versus Piché, and Attorney General of Canada, and it's referenced habeas corpus, and that's found at 4 Dominion Law Reports, page 147. Habeas corpus is a common law writ, and so don't give me that there's no common law in Quebec. There is certainly common law in Quebec. You just have to know how to access it. Anyways, the court case says, quote, "The Magna Carta is not a unilateral act emanating solely from the spontaneous will of the king as the charters of the predecessors of John. Neither is it a treaty, for we cannot say it was concluded between two legitimate and independent sovereignties, nor between two nations, nor is it a law. The barons do not appear in it as subjects, for they are freed from their promise of fidelity, and the king, brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. Magna Carta is therefore a contract, but resembles a treaty concluded between two nations, in that one of the parties, in virtue of the law of war, can impose its will upon the other," unquote. So essentially, what they did is they stuck a sword to his throat, and they said, "Here, king, we want you to sign this." And it was either sign it or we'll run your ass through right now. And excuse my French, but that's the way I would have been putting it. Anyways, so to keep moving here, I'm just doing some other things too at the same time, multitasking. Okay. So, and Section 13 of the Magna Carta, quote, "And the city of London shall have all its ancient liberties and free customs, as well by land and water. Furthermore, we decree and grant that all other cities, boroughs, towns, and ports shall have all their liberties and free customs," unquote. That's Section 13 of the Magna Carta. Section 23 of the Magna Carta, "No village or individual shall be compelled to make bridges at riverbanks except those who were of old legally bound to do so," unquote. Section 24 of the Magna Carta, quote, "No sheriff, constable, coroners, or others of our bailiffs shall hold pleas of our crown," unquote. Section 28, quote, "No constable or other bailiff of ours shall take corn or other provisions without anyone immediately tendering money therefor, unless he can have postponement thereof by permission of the seller," unquote. Section 30, quote, "No sheriff or bailiff of ours or other person shall take the horses or carts of any freeman for transport duty against the will of said freeman," unquote. Well, think about it. That's exactly what they were doing. They were imposing martial law. They were stealing people's corn, and under martial law, they were stealing people's horses and carts, and they were holding pleas of the crown on the side of the road. Essentially, what the cops do today, if you think about it, that's exactly what they do. They interview you. They want to know if they have jurisdiction, and they write you a ticket. And once that ticket is written, then it's a foregone conclusion that you're going to pay the tribute no matter what. So, I mean, the same stuff is going on today. Let's keep going here. Quote, Section 31 of the Magna Carta, quote, "Neither we nor our bailiffs shall take for our castles or for any of our other work of ours wood which is not ours against the will of the owner of that wood," unquote. They were stealing people's wood. Section 38, quote, "No bailiff for the future shall upon his own unsupported complaint put anyone to his law without credible witnesses brought for their purposes, unquote. Well, isn't that what they do? They put you to their law. There's no witnesses. They go and issue this citation, and you have to show up in court. I mean, that's exactly what they do. Quote, to none will we sell, to none will we refuse or delay right or justice, unquote. That's Section 40. What do you think filing fees are? That's exactly what they are. They're selling you their so-called justice. And that's the stuff that's going on all the time. Anyways, the Magna Carta is full of stuff that these criminals were doing, and it's all under martial law. And we talk about it in the presentation on martial law. The Crown is a corporation that's domiciled in the City of London. The Crown is owned and operated by the Vatican. The Crown that belongs to the Queen has ER superimposed over it, and that stands for Elizabeth Regina. All members of the bar are foreign agents of the Vatican. That's exactly what they are. And they were, in America, they were so concerned about this, they passed a Article 13, an amendment. And what's happened is well, first of all, let's read the article. And it's not the one that's currently there, okay? This one, the true Article 13 amendment has been basically swept under the carpet. And I'll explain about what happened. Anyways, the true Article 13 amendment says, quote, if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept or retain any present, pension, office, or emolument of any kind, whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them, unquote. And that's what the true Article 13 amendment says. And I got a certified copy of an 1819 Constitution that was taken from Virginia statutes that has this in it. And so what happened is, first of all, let's talk about this a little bit. They're saying if any citizen of the United States shall accept, claim, or receive any title of nobility or honor, okay, a title of nobility or honor. And then it says some other stuff without the permission of Congress, but we won't even talk about that. And it says from any emperor, king, prince, or foreign power. Okay, the City of London is clearly a foreign power, and a bar member is a title of nobility to get esquire, and it's certainly an honor. And it says they shall cease to be a citizen of the United States, shall be incapable of holding any office of trust or profit under them or either of them. In other words, they cannot hold any position that requires an oath of office. I mean, this is the seriousness, and quite frankly, in my opinion, and this is an issue that I brought up in my first case that I went to the Supreme Court. I brought up the issue that the Vatican wanted their foreign agents of the Crown to infiltrate the government, and so they went and orchestrated the War of 1812 to facilitate the disappearance of this real Article 13 amendment, because one of the major engagements is when they went to the national capital and burned the National Archives. And that's where the records of that article in amendment would have been kept, of the articles of, or the records of the ratification. And so they destroyed all the evidence of this Article 13 amendment, and then what I brought up in my case was that what I brought up was that they were able to get their foreign agents of the Crown to infiltrate the government, and they've infiltrated the government and seized control and operated as their own international criminal racketeering enterprise to this day. And the U.S. Department of so-called Justice waived their right to respond. And if anybody knows anything about what goes on in court, when they waive their right to respond, they basically admit everything. They say, okay, so what? We know about that. And so they're admitting it. So that's exactly what happens, and that's what these bar members are here for, is to seize control and use every justification and scheme they can come up with to violate your rights. And once you understand the law, it's all voluntary. You don't have to volunteer, and you can thumb your nose at them. And if you do it properly, we have a lot of good public servants that do know the law and their oaths of office, and they will do the right thing. And if they don't, then you get them removed. And even the bar members will do that for you. This is taken from Bouvier's Law Dictionary, 1856 edition. Quote, titles, persons. Titles are distinction by which a person is known. And then in definition 3, the Constitution of the United States forbids the tyrant by the United States or any state of any title of nobility. Tyrant, I'm surprised it says that in Bouvier's Law Dictionary. That's interesting. Anyways, it goes on, it says, titles are bestowed by courtesy upon certain officers. The President of the United States sometimes receives the title of Excellency. Judges and members of Congress, that of Honorable. Okay, those are all titles of nobility. And members of the bar and justices of the peace are called esquires. And that's taken from Cooper's Justinian, page 416, and Brackenridge's Law Miscellaneous Index, and it was in Bouvier's Law Dictionary, 1856 edition. So the point is that those are all titles of nobility. An emolument. An emolument is the lawful gain or profit which arises from an office, and that's taken from Bouvier's Law Dictionary, 1856 edition. Esquire is Bouvier's Law Dictionary, 1856 edition. Esquire is a title applied by courtesy to officers of almost every description, to members of the bar and others. In England is a title next above that of a gentleman and below a knight, unquote. And so Esquire is clearly a title of nobility, and so is gentleman and knight, obviously. Anyways, all bar members have renounced their U.S. citizenship pursuant to the true Article 13 and Amendment, and all bar members represent you in court. You cannot have a bar member with you unless he's representing you. Unless the only time you could do it is if you can get a bar member to operate as your counsel, where you go in there and you speak, and he just advises you on things you can do, and you can decide whether you're going to do it or not. That would be a little bit different because he is not speaking for you. You're the one that's doing the speaking. He's in there, and he's just advising you. Now, one of the things I've learned recently, and I haven't added it to this, is that these bar members say they have a license, and actually that's not true. There's no such thing as a license to practice law. Again, remember we talked about that. The practice of law is a common right. Okay, they do get a bar card, and so that's what they have is a card in this private in this union. Basically, it's a union card, and so they have a right to practice law before the courts. Okay, and so that's all they have a right for, and the right that they have to practice law is for imbeciles and idiots and morons and those kinds of people. So again, when you hire a bar member, that's what you're saying is you're an idiot. You're a ward of the court. You're turning yourself into a ward of the court. Okay, the right to be represented exists only in a military court. This is in United States Code, Title 10, United States Code, Section 838A1, quote, the accused has the right to be represented in his defense before a general or special court-martial or at an investigation under Section 832 of this title as provided in this subsection. Okay, that's the only time that you have a right to be represented. Of course, you have the right to counsel, okay, but the right to counsel is different, okay? That means someone advising you, okay? To be represented means someone's in there speaking for you. That's different. That's completely different. It's military court where that goes on. The right to counsel is a common law right, and I think it's the Sixth Amendment that talks about that. I think it's the Sixth Amendment, but it's one of the first 10 amendments that talks about the right to counsel, okay? And the right to counsel is a common law right. Now that means that they're going to counsel you, but you're going to speak. They cannot put you in jail unless you have an attorney representing you, and when you hire an attorney, you volunteer to go to jail. And that's exactly what happens. And here's a court case that even talks about it. Quote, we hold that no person may be deprived of his liberty who has been denied the assistance of counsel as guaranteed by the Sixth Amendment. The denial of assistance of counsel will preclude the imposition of a jail sentence. And so basically, if you, and this is Argersinger versus Hamlin, 407 U.S. 25, this U.S. Supreme Court, 1972. And so if you have a bar member, I can't tell you how many people I know that their lawyers sold them down the river. Okay, there was arguments that they could have brought up and they didn't, and it's because the bar member was running the show. And there's people I know that are in jail to this day because their lawyer sold them down the river, and they make royalties off of this stuff. They get kickbacks. Almost all judges are bar members, state and federal. This is taken from 28 United States Code, Section 631B1. Says, quote, no individual may be appointed or reappointed to serve as a magistrate judge under this chapter unless, one, he has been at least 5 years a member of good standing of the bar of whatever, wherever he lives, basically, unquote. The point is that almost all judges are bar members in Canada, and I'll bet you in England as well. They are all bar members. There's no judges in Canada, certainly I know, that are not bar members. There's statutes that say they have to be bar members. In the U.S., there's in the federal judiciary, they're all bar members, and the state judiciary, not necessarily. There's a lot of elected judges in the U.S., and they may or may not be a bar member. Bar members have infiltrated our courts and are now found at every organization in the country and at the highest levels of government. Obama is a bar member. He's a former law professor. The leader of every major corporation is either a bar member or they surround themselves with bar members. I mean, these people are the lowest form of life there is, and they're just engaged in extortion and all sorts of stuff. Bar members have criminally converted citizenship into the opposite of what the Founding Fathers intended, and this is found at Colgate versus Harvey. This is U.S. Supreme Court, 296 U.S. 404, quote, and while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship, unquote. And so essentially what it's saying is the Founding Fathers, the way the Constitution was written, there was always two classes of citizens. You could be a citizen of the United States and a citizen of the state. Matter of fact, the way the courts were ruling before the Civil War is that a citizen of a state could travel from state to state and enjoy all the rights and privileges of citizenship. And so when you're traveling from state to state, that was what the U.S. citizen was, because you were traveling from state to state. But so the U.S. citizen didn't exist, and there's court cases to say that too. But what happened is this 14th Amendment turned it upside down and made it paramount and dominant. In other words, you can be a U.S. citizen without being a state citizen. And a U.S. citizen is essentially a citizen of the District of Columbia. And so it made it so that you can be, and it also made it so that you can be a state citizen without being a U.S. citizen. And so that's the argument you have to use nowadays. Instead of this other stuff, because they permanently converted citizenship. Bar members have converted a U.S. citizen into a slave. Quote, therefore the U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity, unquote. And that's Wheeling Steel Corporation versus Fox, 298 U.S. 193, U.S. Supreme Court again. Quote, a U.S. citizen upon leaving the District of Columbia becomes involved in interstate commerce as a resident, does not have the common law right to travel of a citizen of one of the several states, unquote. And that's Hendrick versus Maryland, South Carolina Reporters, page 610 to 625, 1914. Bar members are facilitating the murder of millions of unborn children, quote, As used in the 14th Amendment of the United States Constitution, the word person does not include the unborn, unquote. And that's Roe v. Wade, 410 U.S. 113. That's U.S. Supreme Court again. So because the unborn are not a person, therefore they're not a U.S. citizen. Therefore, by definition, they're a state citizen. But millions of women are using this as an excuse to commit infanticide. Infanticide is a common law crime because everything's under martial law. There's no common law, so they can ignore common law, and they only make common law crimes that they feel like making, like treason and sedition and murder. But there's a bunch of common law crimes that aren't made crimes, and they don't have to be under their martial law. And so, like bigotry and infanticide, those are common law crimes, and so they're facilitating the murder of millions of unborn children. That's exactly what they're doing. Bar members have facilitated this imposition of martial law rule. Lincoln was a bar member. Quote, since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's taken from U.S. Senate Report number 93-549, dated November 19, 1973. Do you think anything's changed? Absolutely not. And emergency rule is martial law rule. That's exactly what they're talking about. In a declared national emergency, that's martial law. That's exactly what it is. And we learn about that when we go through the martial law presentation. And and actually, the martial law has been in existence since the Civil War. And so this is what bar members have done. They've gone and facilitated the bankruptcy of the corporation, and they seized control of this corporation for their Vatican handlers, and the Vatican is now operating the United States as an international criminal racketeering enterprise, going and making war in foreign countries, doing all sorts of stuff. Quote, next to revenue itself, the latest extensions of the jurisdiction of the Admiralty are our greatest grievance. The American courts of Admiralty seem to be forming by degrees into a system that is to overturn our Constitution and to deprive us of our best inheritance, the laws of the land. It would be thought in England a dangerous innovation if the trial of any matter on land was given to the Admiralty, unquote. And that's Jackson versus Magnolia, 20 Howard 296. That's U.S. Supreme Court, 1852. And this is what bar members have done for us. They've gone and they're just nothing but a bunch of criminals. They've got this color of law all over the place. Law that is not law, that looks like law, but it's a contract. And once you understand what it is, you don't have to participate. But they got all of this stuff all over the place, and that's another thing these bar members are doing. And we talk about that in color of law. So color means an appearance, a semblance, or a simulacrum as distinguished from that which is real, a prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise or a pretext, unquote. And that's taken from Black's Law Dictionary, 5th edition on page 240. Colorable means that which is an appearance only and not in reality what it purports to be. Hence, counterfeit, feigned, having the appearance of truth, unquote. That's Wendell versus Flynn, 196 Oregon Reports, page 654. Color of law, quote, means the appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law and made possible only because the wrongdoer is clothed with authority of state is action taken under color of law, unquote. And that's Atkins versus Lanning, U.S. District Court for Oklahoma, page 415, Federal Supplements, page 186. And so this is what bar members have done for us. They've gotten all this color of law, and it's all over the place. quote, an unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is an illegal contemplation as inoperative as though it had never been passed. And that's U.S. Supreme Court, again, Norton versus Shelby, 118 U.S. 425. Positive law is law actually and specifically adopted by proper authority, and that's the operative words here, proper authority for the government of an organized juror society, unquote, Black's Law Dictionary, 5th edition. And then an absolute nullity is an act that is void because it's, again, public policy, law, or order. The nullity is non-curable. It may be revoked by any party or by the court. And that's Black's Law Dictionary, 8th edition. And so, again, if you go to the Office of Law Revision Counsel, you will see at the bottom of the front page it says the following titles of the code have been enacted into positive law. Okay, and then it lists a bunch of titles. Well, the ones that aren't positive law is the Customs Act, the Immigration Act, the Homeland Security Act, the hired thugs at the airport that are feeling your crotch and stuff like that. They don't have any authority. The customs crooks, when you're trying to come into the country and they want to know if you're going to pay them some extortion, they don't have any authority. The immigration crooks that harass you to find out if you have a right to come into the country or not, it's none of their damn business. They don't have any authority. The Title 26 United States Code, the Income Tax Act, the IRS thieves don't have any authority. None of them have any authority. They're all a bunch of thieves and criminals. And once you understand it, you can bring up the issue and your problem will probably go away. But it shouldn't be there in the first place if it wasn't for these bar members running the show. This is what bar members have done for us. Don't get me going about these bar members. Anyways, I'm downloading some files here, too, at the same time, so we'll take a little brief 5-second pause. Okay, so the non-positive law statutes is Title 6, Domestic Security, Title 8, Aliens and Nationality, Title 19, Customs and Duties, Title 21, Food and Drugs, Title 20, Education. None of that stuff is positive law. Title 7, Agriculture, Title 26, Internal Revenue. I mean, there's probably half of the United States Code is not positive law, and they're imposing it on you like they're a bunch of thieves. That's exactly what they are. They're just a bunch of thieves. They're criminals, and they're just a bunch of criminals. Anyways, quote, the code is only prima facie evidence of the laws of the United States where an inconsistency between the United States Code and the statutes at large appears. The statutes at large prevail over the code. And that's U.S. Supreme Court, Stephen versus United States, 319 U.S. 423. And the point is that if it's not positive law, then it won't go into the statutes at large. And so they're using that as an excuse. Unless you bring it up, they're just going to railroad you and violate your rights and get away with it because the benchers on the court are a bunch of crooks too. Don't get me going. I got going today, I got to tell you. Anyways, quote, it is well settled that the code cannot prevail over the statutes at large when the two are inconsistent, unquote. And that's, again, American Export Lines versus United States. 290 Federal Report, 2nd edition, page 925, 1961. Quote, Congress, claiming its martial law power to declare war, suppress insurrections, and repel invasions, imposed martial law in the United States and never discontinued it. The result was an extension of the military and municipal jurisdiction of Congress, but where's the evidence of this? Look at the 13th Amendment, the Civil Rights Act, the legal tender laws, the 14th Amendment, et cetera, et cetera, et cetera. And that's a court case called Dyad versus Tanner, 439, Pacific Report, 2nd edition, page 266, 1968. And it's also found in the non-ratification of the 14th Amendment by Judge A.H. Ellett, Utah Supreme Court. It is, quote, It is an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt, being bankrupt and insolvent. House Joint Resolution 192, 73rd Congress in session June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental officers, offices, and departments, and is further evidence that the United States federal government exists today in name only, quote, unquote. That's United States Congressional Record dated March 17, 1993, and that is still going on to this day. And what they're essentially saying is that they're all de facto. They don't have a shred of authority. There's nothing they do that has authority, and they're just a bunch of criminals. If you go to Dun & Bradstreet and do a search for United States of America in the District of Columbia, you will find that you will come up with the United States of America 4 Corp. And what that means is the first 3 were liquidated in bankruptcy, and we're on number 4. Okay, well, let's take a little break, and we'll get Kat to play a song here, and I'll come back in about 5 or 10 minutes and continue on with this presentation. Good afternoon, everybody. This is Glenn Winningham, House of Fern. We're talking about attorneys. Everybody loves attorneys. As you can tell from what I say, I certainly love attorneys. Anyways, if anybody wants to know anything about some of the stuff I do, I've got a website. It's sovereigntyinternational.info. That's all one word, sovereigntyinternational.info. You're listening to Do You Know Who You Are? The program is Do You Know Who You Are? And the radio station is These Changing Times Radio. Now, I also have a group on These Changing Times Radio. It's also called sovereigntyinternational.info. Ultimately, this program will be uploaded to YouTube as a YouTube video, and so you can access it there. So I have a YouTube profile. It's called Sovereign Living, but I will be putting a link to this video on my group, and so you'll be able to find it there, the link there as well. I've also uploaded some files that you will find interesting. I've uploaded, for example, a letter from an Arizona senator talking about the contractual nature of driver's licenses and registration, and how some people in Arizona have rescinded all of their contracts and have become freemen. And so, and that's from an Arizona senator. That's on that website. It's a certified and apostilled copy. So it's very powerful. Anyways, so let's keep moving on this presentation on attorneys. Hopefully we'll get it done here. Should get it done by the time, in another, about 50 minutes. Quote, the 14th Amendment is an extension of national military powers presently used in a municipal character and enforced by municipal laws stretched far beyond their original limitation and enforced by Article 1 tribunals, unquote. Well, and so they're talking about martial law here is what they're talking about, and this is more, you'll see this kind of stuff talked about on my presentation on martial law. This is taken from a court case called Dyett versus Turner, 439, Pacific Report, 2nd edition, page 266, 1968. And it's also taken from a book called Non-Ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court. Again, it's martial law, and that's what this is all talking about. Tribunals come from canon law in the Vatican. Go to the Vatican's website. I printed off several pages here, the Code of Canon Law, and it talks about tribunals all over the place. It all comes from the Vatican. Tribunals are military courts. The military, all martial law comes from the Vatican. Quote, as we have said, the federal personal income tax is collected under a military venue within a martial law jurisdiction. Federal Reserve notes are military scripts circulated within a military venue. The problem is that people don't understand how the entire United States is covered by a military venue. Under the Social Security Act, there's brought into existence 10 federal regional areas. These 10 federal regional areas are the same as a military base. It is not unconstitutional to circulate military script on a military base, as the base is considered to be a military venue. Military script cannot circulate in the civil jurisdiction of the several states. To get around this constitutional bar, the Congress, via the Social Security Act, created 10 military venues called federal regional areas. The problem the Congress realized, while the Congress could restructure the government agencies into these federal regional areas, the people could not be identified to be within this military venue, but by their own consent, unquote. And that's taken from a court case called Dyett versus Turner again, and a book called The Non-Ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court. And that court case goes on to say the solution was to create another military venue, which would trick the people to voluntarily accept recognition that they're within a military venue. Congress solved this problem by creating the zip code. The zip code divides the United States into 10 military venues called national areas. When a citizen receives mail from an agency of the federal government, such as the IRS, and the return address of the federal agency is the district within the regional area the letter was sent from, and on the address of the citizen, it was sent to the national area in which he received the correspondence from the IRS. In other words, The correspondence was sent from one federal regional area, a military venue, to one of the national areas, another military venue. Taxing districts are established within one of the federal regional areas, which places the collection of taxes under a martial law jurisdiction. And that's again taken from that non-ratification of the 14th Amendment. This is all because of bar members. They lay awake at night with this stuff. The crimes of bar members are too numerous to list. Bar members have converted our nation from a Christian nation that it was intended to be into a nation of hedonists and devil worshippers. They've taken God out of our school and our court. The number one export of the United States is entertainment. I don't know how many people know that, but the number one export of the United States is entertainment. Now, I mean, hello, that's telling me that we're a hedonistic society. All U.S. courts are territorial courts. The quote, the United States District Court is not a true United States court established under the Constitution, Article 3, to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3, of making all needful rules and regulations respecting the territory belonging to the United States, unquote. And that's Balzac versus People of Puerto Rico, 258 U.S. 298. That's U.S. Supreme Court. Quote, in other words, when state martial law is imposed within the state to enforce national martial law, Congress has no reason to exercise its martial law powers. If a state has conformed to the new order, there is no need for Congress to intervene. And if citizen has not obtained the standing of a former slave by petitioning Congress for admittance to venue and jurisdiction of the 14th Amendment, then Congress has no power over that individual under this clause, unquote. So what they're saying is, again, it's all voluntary. If you don't do something to turn yourself into one of their statutory persons, then you're not in the venue. You're not a slave, okay? But if you do something to get you into that jurisdiction, you volunteered in. And that's, again, Diet versus Turner, 439, Pacific Report, 2nd edition, page 266, and the non-ratification of the 14th Amendment by Judge H. Ella to the Utah Supreme Court. Quote, when a state forms a constitution which is approved by Congress, it is a stop to deny its validity. The action of Congress cannot be inquired into, for the judicial is bound to follow the action of the political department. And that's found at Luther versus Borden, 48 U.S. 1, U.S. Supreme Court, 1849. So what they're essentially saying is that the U.S. Supreme Court can't rule on the constitutionality of any amendment because of the fact that Congress, they cannot inquire into the actions of Congress about that kind of stuff. And that's why they don't. But in the U.S. Supreme Court rules, Rule 45, it says, quote, all process of this court issues in the name of the President of the United States, unquote. Well, think about it. That means that the President, even the U.S. Supreme Court is executive. There is no judicial courts. They're all a fraud. They're just doing what the President tells them to do. Quote, over the years, the people have had a great deal of trouble accessing the judicial power of the courts. Since martial law suspends the judicial power along with other regular powers of government, this is quite understandable. Congress's power is practically speaking unlimited, where the regulation of courts subjected to martial law rule are concerned. Therefore, why would Congress think that their power over the martial law measures in general is limited to the Constitution, especially since Congress claimed power under martial law with the power clauses of the 13th, 14th, and 15th Amendments, unquote. And that's, again, Diet versus Turner and the non-ratification of the 14th Amendment by this Judge H. Ellett. Is there any wonder why Christ had such complete and utter contempt for the attorneys of his day? Under the Lateran Pact of 1929, Italy agrees to give the Vatican all the rights of a sovereign nation. Canada, United States, and most other nations have signed on to the Lateran Pact. Under the Lateran Pact, the Vatican is considered neutral territory and sovereign. And there's also another thing that I mentioned yesterday, the 1933 Concordat. It says in there that, and I talked about this yesterday when we were talking about citizenship, I think I did. I'm pretty sure I talked about it yesterday. Anyways, in the 1933 Concordat that Hitler did with the Vatican, it says that a priest's clothing and a nun's habit is a military uniform. So again, that's just further proof that all this stuff is coming from the Vatican. That's the end of this presentation, and I'm adding things from time to time, so by the time I do this again, I'm sure there's going to be a few things added. But the point is that all of this is done thank you to bar members, and it all comes from the Vatican. And the sooner we start to understand this, and these bar members don't have a shred of authority. They're not your friend. They're not there to help you. They're there to line their pockets and steal as much as they possibly can. And the sooner we figure this out, and the sooner we take steps to protect ourselves, the better. These people are just nothing but criminals. They're the lowest form of life there is, in my opinion. Anyways, the next presentation we're going to go through is, we got about 40 minutes, so we're not going to be able to cover very much. We've already done citizenship and churchianity, and so we'll do color of law. And this is another nice thing that the Vatican has brought us, or I should say the attorneys and the Vatican. Certainly more than just the Vatican. I mean, it's attorneys too in that case. Color of law. And we won't get it finished, so we'll have to finish it on Sunday when I do my next program. There is color of money, there is color of justice, there's color of title, and there's color of law. Now, you remember we talked about color of law in the last presentation on attorneys. And because attorneys have brought us color of law. And so we'll talk a little bit about what color of law is, but those definitions are further on. There's two kinds of legislative law. There's positive law and non-positive law. Positive law is law passed with legitimate authority, law passed to protect the rights of the people. That's taken from Black's Law Dictionary. And then non-positive law is colorable legislation, and that's taken from Dictionary of Canadian Law, applies to certain groups of people, and does not apply to sovereign citizens, and it operates as a contract for sovereign citizens, and it actually turns you into a subject. And a subject is property. It's a slave. All of this is about slavery, and the sooner you figure it out, the better, because you don't have to be a slave, but you can volunteer to be a slave, and that's the way they're looking at it, is you volunteered to be a slave. And so we have to quit volunteering. Anyways, positive law. Quote, positive law is law actually and specifically adopted by proper authority for the government of an organized rural society, unquote. That's taken from Black's Law Dictionary, 5th edition. Now, proper authority means that it's done by proper authority. If it's not positive law, then it's not done by proper authority. And there's certain things that have to happen for an act to be done by proper authority. In other words, in the legislature or parliament, it has to be read 3 times. There has to be a preamble. There has to be a reason for the act. There's got to be certain things in that act. Then it also has to be presented in the Senate, and the Senate has to approve it. And I'm not sure if it has to be read 3 times, but there's still procedural things that have to happen in there. And then finally, it has to have, in England or Canada, it's got to have royal assent. In the U.S., it's got to be signed by the president. And so what happens is that most of them have defects in them. And fortunately, in the U.S., there's the Office of Law Revision Council, which is the U.S. House of Representatives website that tells you what's enacted as positive law. And we talked about that before. And we talked about how domestic security is not positive law. Aliens and nationality, Title 8 United States Code is not positive law. Title 12 banking is not positive law. Title 19 customs and duties is not positive law. Title 20, education, is not positive law. Title 26, internal revenue, is not positive law. There's half of the United States Code is not positive law. In Canada, the Income Tax Act never received royal assent. In England, and this is affecting Canada, the British North America Bill never received royal assent. Therefore, there is no Canada. Think about it. Remember, we talked about that. An unconstitutional act doesn't do anything. And these are, if it's not positive law, it's by definition an unconstitutional act. They have no authority. And so the British North America Bill never received royal assent. So therefore, everything done subsequent to that means absolutely nothing. The Customs Act never received royal assent. The Immigration Act never received royal assent. In Ontario, the Highway Traffic Act never received royal assent. And the reason they don't receive royal assent, quite frankly, is because the Governor General or the Lieutenant Governor or the Queen, depending on who it is and where you're at, knows whether the thing was properly enacted. And they're not going to sign it unless it was properly enacted, because if they did, it would be perjury of oath. And so they all have oaths. If the British North America Bill never got royal assent, then there is no British North America Act, and anything done under the British North America so-called Act is a fraud and a nullity. Quote, an unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protection, it creates no office, it is in legal contemplation as inoperative as though it had never been passed, unquote. And that's Norton versus Shelby County, 118 U.S. 425, U.S. Supreme Court. Non-positive law is color of law by definition, okay? Now remember, let's go back to, we're going to get into some words here. It says here in the Office of Law Revision Council's website, in the third paragraph from the top, it says, quote, it says, certain titles of the Code have been enacted into positive law and pursuant to Section 204 of Title I of the Code. The text of those titles is legal evidence of the laws contained in those titles. And then it goes on, it says, the other titles of the Code are prima facie evidence of the laws contained in those titles. Okay? So the word that we want to talk about is prima facie. Okay, that's Latin, and we're going to talk about that here in a little bit. Non-positive laws have no authority and mean absolutely nothing. They are by definition de facto. If there's any defect in the legislation, then there is no act. Patrick Ellis, a friend of mine, correctly calls the BNA Act the BNA bill, because that is all it is, and it means absolutely nothing. Colorability, quote, colorability, a doctrine invoked when a statute is addressed to a matter outside jurisdiction, though it bears the formal trappings of a matter within jurisdiction of the enacting legislature, unquote. That's P.W. Hogg, Constitutional Law of Canada, 3rd edition. Quote, colorable in appearance but not in substance what it claims to be, unquote. And that's taken from the Dictionary of Canadian Law. And there's some definitions from Black's Law Dictionary. Quote, color means an appearance, a semblance, a simulacrum, as distinguished from that which is real. A prima facie or apparent right. Remember, prima facie was on the Office of Law Revision Council. Okay, so a prima facie or apparent right. So if it's, remember, it said that the other titles of the Code are prima facie evidence of the laws of the United States. That means they're color of law. Okay, so let's start over again here. Black's Law Dictionary, 5th edition, on page 240, says, quote, color means an appearance, a semblance, or a simulacrum as distinguished from that which is real. A prima facie or apparent right. Hence, a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise or a pretext, unquote. That's taken from Black's Law Dictionary, 5th edition, page 240. So that ties in prima facie really nice. Colorable means that which is in appearance only and not in reality what it purports to be. Hence, counterfeit, feigned, having the appearance of truth, unquote. And that's Wendell versus Flynn, 196 Oregon Reports, page 654. Color of law means the appearance or substance without the appearance or semblance without the substance of legal right. Misuse of power possessed. Whoops, I moved it. A misuse of power possessed by virtue of state law made possible only because wrongdoer is clothed with authority of state is action taken under color of law, unquote. And that's Atkins versus Lanning, U.S. District Court for Oklahoma, found at 415, Book 415, Federal Supplements, page 186. Prima facie, this is the definition of the word prima facie. Quote, prima facie, at first sight, on the first appearance, on the face of it, so far as can be judged from the first disclosure. Presumably, okay, here's another word that we're going to be talking about, presumably or presumed, okay? Presumably, a fact presumed to be true unless disproved by some evidence to the contrary, unquote. And that's State ex rel. Herbert versus Williams, 68 Ohio Appeals, page 39. It's also found at 38 Northeast Report, 2nd edition, page 596. And this is taken from Black's Law Dictionary, 5th edition, at page 71. So, remember, it talks about prima facie is color of law. Remember, the non-positive law titles of the United States Code are prima facie evidence of the laws of the United States. What they're essentially saying is it's a fact presumed to be true unless disproved by some evidence to the contrary, okay? And that's what my procedure does, okay? My procedure builds evidence that says that their color of law statutes mean nothing to me, okay? And see, you have to notice them. You have to, because they've gone and passed these color of law statutes, because they're owned and operated. The reason is, and we get into this when we do my ultimate solution to your government presentation, okay? The reason is the government's bankrupt. Remember, we talked about that. The government's bankrupt. It's owned and operated by the international bankster thieves and their Vatican handlers. And so they have a duty to make their Vatican handlers money. And so what they do is they pass laws that really don't apply to anybody, and if you get involved in them, then the courts view it to be a contract. You've agreed to it. Ignorance of the law is no excuse, even at common law. Ignorance of the law is no excuse. So you're supposed to know the law. So that's why my procedure works so well, okay, is because I put them into estoppel. They are stopped from proceeding. They are, and that's what I present evidence to the contrary, or I build evidence, okay? In other words, I send them a letter, and it's got all of my it's called estoppel certificates. I send them a letter, and now it's like 20 pages, 150 paragraphs with court citations and all sorts of stuff in it. And I send it by registered mail, okay? Registered mail is important because it's kept under lock and key, and there's a chain of custody that's kept by the post office. You are effecting service when you send it by registered mail. And so I send it by registered mail, and I serve it on them. And I take away their presumptions. Remember, that's talking about presumably, a fact presumed to be true unless disproved by some evidence to the contrary. I take away their presumptions. And the power of what I do is that the Texas State Police and the FBI came and told me that I'm listed as sovereign in their system. And, you know, there's a lot of people that say that when you register a vehicle, that you're turning it over to the state and it's a contract and all that, and that's true if you're a person. But one of the things I tell them is I'm not a person, and I tell them that my truck might have Texas plates on it, which it does. I said, but I put on it private vehicle on the back and the rear bumper area, and I don't care whose plates are on it. It's my vehicle. And what happens is that that's kind of useful because now they see me and they know there's a friend of mine in Texas that actually came up to me and he told me that a cop came up to him and said, quote, "Why is my computer telling me to leave you alone?" unquote. Well, I guess that's what their computer is saying about me, since they listed me as sovereign in their system. And so the reason is that I don't care whose plates are on it. I'm taking the vehicle back. I'm the king. There is no contract that you can get me into to make me give up my rights. That's called treason. And so there is no contract, and I've seen lawyers go into court and make that argument where I was suing somebody, and the lawyer would come in and say, quote, "There is no contract, it's a nullity." Okay? In other words, for someone that's a slave, it's a contract. But I am the king. And so it's treason for them to get me in a contract, so it's a nullity. Remember, we talked about a nullity earlier in this presentation. And so it's not like I do a lot of things. That's about the only thing that I have that's in their system, and it's kind of useful because they know to leave me alone, basically, and they do. And again, do you know who you are? Okay, you have to defeat their presumptions, and that's what all of this color of law stuff is all about. So let's keep moving. Quote, "The code is only prima facie evidence of the laws of the United States where an inconsistency between the United States Code and the statutes at large appears. The statutes at large prevail over the code." And that's Pert versus Motor Vessel Bearing Explorer, 373 Federal Supplements, page 927, April 12, 1974. And there's lots of court cases that talk about this. We talked about them in the last presentation about attorneys. This is a good one. This is taken from, Washington. Quote, "But the legislature specifically disclaimed any intention to change the meaning of any statute. The compilers of the code were not empowered by Congress to amend existing law, and doubtless had no thought of doing so. The act before us does not purport to amend a section of an act, but only a section of a compilation entitled Revised Code of Washington, which is not the law. Such an act purporting to amend only a section of the prima facie compilation leaves the law unchanged." And that's Tarosa versus Tacoma, 57 Washington Report, second edition, page 409, 1960. I just found that very interesting. It's kind of relevant to this matter, but in a way it's not. But it's interesting. Anyways, quote, "An unconstitutional act is not law. It confers no rights. It imposes no duties. Affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed," unquote. And that's Norton versus Shelby County, 118 U.S. 425. That's all that color of law, that United States Code, or every country has it. I guarantee you it's in England. It's all over the place. There's nothing in Canada that's positive law. And in their own definitions, it even says it. An absolute nullity. And this is what I've seen lawyers go in cases where I've been involved in, where I was suing somebody, and the lawyer would come in and say, there is no contract, it's a nullity. And, quote, "An absolute nullity, an act that is void because it's against public policy, law, or order. The nullity is non-curable. It may be invoked by any party or by the court." And that's Black's Law Dictionary, 8th edition, page 3391. Okay, keep moving here. Adjustum generis. This is a Latin for of the same kind. This is another Latin word. Okay, remember we talk about a lot of this Latin, and the reason that all of this Latin is used is because it all comes from Roman law. Okay, this is all coming from Roman law. Okay, the Vatican. That's exactly where it's coming from. But it's voluntary. You have to volunteer into it. Anyways, adjustum generis, Latin for of the same kind, used to interpret loosely written statutes. Where a law lists specific classes of persons or things and then refers to them in general, the general statements only apply to the same kind of persons or things specifically listed. Example, if a law refers to automobiles, trucks, tractors, motorcycles, and other motor-powered vehicles, then vehicles would not include airplanes since the list was land-based transportation. And that's taken from Black's Law Dictionary, 8th edition. That's a maxim of law. Okay, that's important, that it's a maxim of law. Maxim of law is something that is very well settled in the law. It's everybody in the law knows about it. Okay, so it's very well settled in the law. It's old as time itself, and the stuff we're talking about is as old as time itself. You know, when we talked about citizenship, okay, I went back to the Old Testament. Because there's two classes of citizens in the Old Testament. The children of Israel were strangers in the land of Egypt, and so that's a stranger's an alien, and versus someone that's born in the land. That's exactly what they're doing today. It's all about the stuff that's been going on since the beginning of time. Anyways, Title 26, United States Code, Section 7701A1 says, person. The term person shall be construed to mean and include an individual, a trust, a state, partnership, association, company, or corporation. Okay, so based on that, I'm not going to let you think too long on this, but what's an individual? Okay, it says the term person shall be construed to mean and include an individual, a trust, a state, partnership, association, company, or corporation. Well, what they're saying is an individual is a type of a fictitious entity. That's exactly what they're saying, okay? Most people don't know that, and so most people think, well, I'm an individual, so I guess that means me, because this is 26 United States Code, Section 7701. That's the Income Tax Act, or the so-called Income Tax Act, and so even in their definitions, it talks about, it's all very properly done. They're very careful to make sure that it's done properly. And there's lots of court cases that talk about this stuff. And so that's why I say the Income Tax Act really doesn't apply to anybody. And anybody that pays any money in the Income Tax Act, it's a gift. That's exactly what it is. It's a voluntary donation. Even if you look in the Internal Revenue Procedures Manual, the section that they use to go against people has to do with gift taxes. It's a gift. So we know based on a justum generis, an individual is a fictitious entity. Let's go on. Include. And this is another taken from Black's Law Dictionary, 4th edition. Include means to confine within, to hold as an enclosure, to take in, attain, shut up, contain, enclose, comprise, comprehend, embrace, involve. And this actually taken from a whole bunch of court cases, and I won't even start reading them all because there's probably 20 court cases here. So it's well established in the law that that's what include means. Here's some more definitions of include. This is taken from American English Dictionary of English Language, Noel Webster, 1828. Include, definition number 1, is to confine within, to hold, to contain, as the shell of a nut includes the kernel. A pearl is included in a shell. And then definition number 2, to comprise, to comprehend, to contain, unquote. That's American Dictionary of English Law with Noel Webster. Okay. And then here's some more stuff include, taken from Black's Law Dictionary, 6th edition, page 763. Include, Latin, includere, to shut in, keep within, and then and in brackets, and then it goes on. It says to confine within, hold as an enclosure, take in, attain, shut up, contain, enclose, comprise, comprehend, embrace, involve. And that's taken from a court case, Premier Products Company versus Cameron, 240 Oregon Reports, page 123, and that's taken from Black's Law Dictionary, 6th edition. And so include means it's limiting. And the reason I'm bringing that up is we're going to go back to this, Title 26, United States Code, Section 7701A1, and it says person. The term person shall be construed to mean and include an individual, a trust, a state, partnership, association, company, or corporation. Well, if you know anything about the law, then what they're saying is shall be construed to mean and include is basically means mean, and so they put that in there to confuse the people out there that don't want to go and learn the law and learn about what's happening here. So confuse them to get them to volunteer in, because really what they're saying is the term person shall be construed to mean an individual, a trust, a state, partnership, association, company, or corporation. That means it's all it is. There's nothing else that's there that's not listed specifically. U.S. Supreme Court, Montello Salt versus Utah. That's found at 221 U.S., page 455. Include or the participial form thereof is defined to comprise within, to hold, to contain, enclose, comprise, comprehend, embrace, involve. Okay, that's right from the U.S. Supreme Court. I mean, I think I beat that one to death. So anytime you see include, it means that it's limiting. And here's another maxim of law: expressio unus ex exclusio alterius. Okay, more Latin. Okay, Roman law. A canon of construction. I mean, why is it difficult to understand this is Roman law? It says right here, a canon of construction. It's obviously Roman law. It's a canon. Holding that to express or include one thing implies the exclusion of the other or the alternative. For example, the rule that each citizen is entitled to vote implies that non-citizens are not entitled to vote. Now, there's two kinds of citations that you'll see. There's a citation that's actually a quote from the court, and it'll be in quotation marks, but there's also a citation that is a summary. And so just to give you an example, here's a court that's a citation, a quote, from a case called U.S. versus Minker, found at 350 U.S. 179, 1956. Quote, but the subpoena is in the form of an official command, and even though improvidently issued, it has some coercive tendencies, either because of ignorance of their rights on the part whom it purports to command, or their natural respect for what appears to be an official command, or because of their reluctance to test the subpoena's validity by litigation, unquote. And what they're talking about is, this is a case where the IRS sent someone a subpoena to appear, and the IRS subpoenas are a fraud. Okay, IRS doesn't have authority to issue a subpoena, and so if you get a subpoena from the IRS, throw it in the garbage, because that's what it's good for. And there's court cases to talk about it. Matter of fact, I'd be surprised if you get one, because they know. But there's a summary that I like way better, and this is a summary. And the summary says, because of their respect for what appears to be a law, many people are cunningly coerced into waiving their rights due to ignorance. And I like that way better, because that's essentially what it says. and that's so true. There's another quote, and this one is actually, I'm not even going to cover it all. I'm just going to start it, because it goes through about 2 pages in this court case, and it just goes on and on. But this is taken from Penn Howell versus Doan's Administrators, found at 3 U.S. 54, 1795, at page 93. Anyways, it starts off, it says, a distinction was taken at the bar between a state and the people of a state. It is a distinction I'm not capable of comprehending. And it goes on in this 2-page diatribe and explains why he's not capable of comprehending it, okay? But I like the summary way better, because this is the summary. And it's not 2 pages. It's quite short. Well, fairly short. Anyways, the summary says, inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can only interface with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. And that's the end of that summary. And that says it so well. And I can't tell you how many times people say that there is nothing the government can do to affect the people. And it's so true. There is literally nothing the government can do to affect the people. And this is an old court case, 1795, Penn Howell versus Stone's Administrators, and that's essentially what it says. And so you got to think of it like it's the Matrix. And this is what it's talking about: is that if you're an artificial person, then you're in the Matrix. And if the government is dealing with you, then you're in the Matrix. And you need to take yourself out of the Matrix. Everything is an illusion. There is nothing the government can do to affect you. Everything is an illusion. We, the people, are kings and queens. And the sooner you understand that, the sooner you'll start to be free. Because as long as you're anything to do with the government, you're a slave. You're either a slave or you're free. And there's nothing in between. There is nothing in between. Do you know who you are? And that's what this is talking about. Do you know who you are? And that's what this presentation's about, is color of law, and that's what we're talking about today. All codes, another summary, okay? And this is Rodriguez versus Donovan, found at 769 Federal Report, second edition, page 1344. And it says that the summary is, all codes, rules, and regulations are unconstitutional and lacking in due process. Okay? Again, there is nothing the government can do to affect the people. And you have no idea the power you have. They know it, because it's even in their own definitions. And let's go and look at some definitions now in their statutes. And here's Canada. And this Section 35.1 of the Interpretation Act of Canada. And in the very beginning of this section of this act, it says, in every act, the following definitions apply. And it says here, Canada, for greater certainty, includes the internal waters of Canada and the territorial sea of Canada. So that's all Canada is. That's what they're saying. Canada is the internal waters of Canada and the territorial sea of Canada. Canada is Admiralty Maritime Law. In the same act, it says person, or any word or expression descriptive of a person, includes a corporation. So a person is a corporation. They know they don't have a shred of authority over you. In the Criminal Code of Canada, Section 2, it says, every one, person, and owner, and similar expressions include Her Majesty and an organization. Again, the Criminal Code only applies to fictitious entities. They know it. The burden's on you to bring it up. And this is also in the Criminal Code of Canada. Municipality includes the corporation of a city, town, village, town, county, township, parish, or other territory or local subdivision of a province, the inhabitants of which are incorporated are entitled to hold property collectively for a public purpose. Well, this is actually true. If you're in a corporation, then you're a slave. And you have to be very careful how you do your documents, because you want to make it absolutely clear that you're not in a corporation. And you can be on the land and not in the corporation, okay? In other words, it's all in what you put down. For example, there's New York City and there's City of New York. I mean, everybody's heard both of those terms, okay? New York City and City of New York. Well, New York City is the land around New York, where the city sits. And the city of New York is, when they go and use words like that, the proper English says that the adjective describing the proper name, okay, the proper name is New York. The adjective, city, is supposed to follow the proper name. And so New York City, that's proper English, okay? And that is something that's real, therefore, okay? It's not in the Matrix. And when they put City of New York, that's not proper English. So then that's a fiction that's in the Matrix. It doesn't exist. And so, again, I can't tell how many people go and make an affidavit and say, City of Toronto, Regional Municipality of Toronto. That's like, you might as well take a gun and blow your brains out. What I would put is I'd put Toronto County, and I guarantee you Toronto County exists, and I've done it, okay? And I've been into their courts, and they've never ever said anything, okay? I put Toronto County and Ontario Republic or something like that. That's probably what I would do. Again, you have to think outside the box, and you are the one that decides where you're at, okay? I don't care what they say. They don't have any authority to represent you. Everything they do is under color of law. If some lawyer wants to complain about it, fire his butt. He's representing you, and don't let him get away with it. Quite frankly, if they try doing that stuff to me, I get mad. And I start dumping on them and filing, complaints with the bar and make it into their worst nightmare. And quite frankly, I never hear anybody say anything, and I think it's because they know that's what I would do. And so you decide who you are and where you're living. I always say I'm an inhabitant of the land of Ontario or the inhabitant of the land of Delaware, and I'm not in your corporation state of Delaware. And I specifically tell them that. Right now I'm in Delaware, but I'm on the land of Delaware, and I'm not in the state of Delaware. And here's Alberta Interpretation Act, Section 28(1) NM. And it says, person includes a corporation and the heirs, executors, administrators, or other legal representatives of a person. Again, it's all corporations or lawyers. Has nothing to do with me. Alberta Traffic Safety Act, driver means a person that's driving or actual physical control, okay? So, I still don't understand how a fictitious entity can be driving because, there's someone sitting in the seat. But that is true. The only thing they have authority over is people that are doing it for hire, okay? And so, therefore, if you're doing it for hire, like a bus driver or a truck driver, then you are a person. But otherwise, you're not. If you're just traveling with your private property, then you're not driving. Actually, you're traveling. The Interpretation Act. They put this in the Interpretation Act. Quote, no enactment is binding on Her Majesty or affects Her Majesty or Majesty's rights or prerogatives in any matter unless the enactment especially states that it binds Her Majesty. And actually you see this prerogatives all over the place in court cases and stuff too. And think about it. The Queen has an oath of office, so she is my servant. When I send her a letter, or if I send the President a letter, whoever, I tell him, I don't owe you allegiance. You owe me allegiance. I'm the king. You owe me allegiance. You have the oath, and I demand that you honor that oath. And so I guess what my point is that you have to stand up and give instructions to your public servant. Anyways, we're obviously not going to get through this. I got quite a bit more to go, so we'll have to cover it. If anybody wants to hear the end of it, you'll have to come on Sunday night and listen in. and we'll be talking about Tower of Law, and we'll probably talk about another one too, at least one more. And so if you want to come on Sunday night and listen to it, you can come then. Otherwise, I appreciate Kat letting me be on, and hope you've learned something, and maybe you're starting to get an idea on who you are. If you keep listening, and never take my word for this stuff, okay? Do your own research. Never take my word. Anyways, you're listening to These Changing Times Radio. The program is Do You Know Who You Are? I've got a website, sovereigntyinternational.info. I've also got some groups. There's a group called sovereigntyinternational.info on These Changing Times website. I've also got two private groups called Administrating Your Public Service. Those are separate words, and they're at Yahoo and Google. I've also got a YouTube profile, and that's called Sovereign Living. And you can get everything available on the internet for free to assert your sovereignty. And I've made it all available for free. I do have some stuff that's available for a price, but you can get it for free on the internet, but you have to do some research. Of course, for a price, I'll come and do a private information share, and I have some DVDs that are available as well. But at any rate, I guess I ought to turn the time over to Kat, and everybody have a good weekend, and for those of you I'll see on Sunday night, we'll see you then.
Another wonderful show there, Glenn. Thank you very much. Just to remind you, you have been listening to the wonderfully wise Glenn Winningham. Do You Know Who You Are is the name of the show. And as Glenn said there, he will be back on Sunday. That is 5 p.m. to 8 p.m. CST USA, which is 6 p.m. Glenn's time, Eastern time, I do believe. And that's 11 p.m. to 2 a.m. in the UK and Ireland. But do stay tuned for Earthships and Gateways with host Tara and Dave, which is always a lovely show about very natural things. But as Glenn said, he is here with us again on Thursdays. His Thursday night show is 11 p.m. to 1:45 a.m. that's UK and Ireland, which is 5 p.m. to 7:45 p.m. CST USA, and that's again 6 p.m. where Glenn is, and he's on a Friday now. So Glenn does have, if I can say, his own trinity. So it's been a pleasure as ever, and you're listening to These Changing Times, times with a Z or a Z, depending on when in the world you come from, These Changing Times radio.ning.com. So do tune in on Sunday to hear the wisdom of Glenn once again. Thanks everybody, and soft parts.